Good morning. May it please the court, I'm Tom Elliott here on behalf of the intervener who intervened on behalf of the estate. In this case, we have the bank using a judgment.
Did you want to save any time for rebuttal?
Oh, yes, thank you, Your Honor. 4 minutes, please.
4 minutes?
4 minutes, yes.
All right.
We have the plaintiff bank using a foreclosure judgment from the first suit in which the estate, and the decedent before there was an estate, was never a party as the basis for its judgment against the estate in the second suit. Simply can't do that. It did not sue on the notes in the second suit. The notes were merged. Everybody agrees the notes were merged into the deficiency judgment. It did not sue the estate in the first suit. This court has repeatedly said you can't use a judgment from one case to impact somebody who wasn't a party in that case. The Hutchison case is one of the most recent pronouncements of that. It's an opinion by Judge Wallace. An eviction there was based on a foreclosure suit, but the resident was not in the foreclosure suit. And this court says you can't do that. It is void as to that resident who was not in the foreclosure suit. And they argued, they said, oh, well, but the deed he got was no good. And this court in a footnote says, we don't care about the deed. That's not an issue we're addressing. You can't use the judgment from suit 1 against a non-party in suit 2. And that's exactly what happened here. Now, they don't really dispute that. What they say is, oh, but we've got this 1930 case that lets us use it as evidence. Let's look at the problems with that. They cite some other cases too, but if you look at all their other cases, they're cases that the maker of the note was also sued in the foreclosure action. I mean, most of the time, the maker and the mortgagor are the same person. That wasn't the case here. There was a trust that was the mortgagor, and the estate, the woman who became the estate, was the maker on the note. So most of the time, they're in there together, and you can clearly sue together. Couldn't do that in 1930, apparently, and that's why the whole analysis they're trying to do breaks down. It's an after-fact analysis. That case is never cited in their motion for summary judgment. It's just once we've gotten to the appeal, that's kind of come up as, oh, now they're going to try to justify it that way. But this is the young husband case, kind of a weird name, from 1930, and there are 3 independent reasons why that case does not save them. That's the case they rely on. It's an 85-year-old case.
Does that mean it's settled law?
It means it is overruled law because the Supreme Court 10 years later basically retreated from that. And that's the second reason why there's a problem. But there's even a more basic problem. In the young husband's case, apparently at that time, when you read those things, and what you see 10 years later in the Degay case, Degay, however it's pronounced, that we cite in our reply brief, you couldn't sue. You could, in Chancery Court, on the mortgage foreclosure, you couldn't sue the maker if they were separate or the endorser if they were separate. The Chancery Court could only do one thing. It could do the foreclosure. It couldn't go ahead and do the deficiency judgment. So what the court says in young husband, it says it addresses what do you do? It says you bring a suit on the note, a separate suit on the note. And it says that repeatedly. Look at page 727. It says, but the right of act, and this is talking about going to sue. There it was an endorser. A bank had served as an endorser on this mortgage note. It says, but they say, but the right of action is not upon such findings, meaning findings in the foreclosure suit, quote, but is on the original obligation, whether a note or bond. Later on the same page, 727. In other words, the suit should be on the note for any balance due and not on the findings of the chancellor. Well, that's a problem for the bank here because they have no notes. The notes were merged into the foreclosure judgment. They deposited the notes into the first action. So the notes are not there anymore. So first reason they can't rely on Young's husband is they can't bring a note suit. They don't even claim they brought a note suit. If you look at the exhibits, well, they try to claim later on, oh, well, the notes are in the foreclosure judgment and we're suing on the foreclosure judgment. No. They're not suing on the notes. The notes are not even listed as exhibits to the complaint in the second action against the estate.
So if we agree with your argument, you're asking us to reverse the court, vacate the judgment, and they have no remedy.
What remedy they might have in some other place, some other way, it's not for me to tell them. We're in a, but yes, if they did it wrong, Judge, I mean, they can't do what they've done here. This has clearly got to be reversed because you can't use the judgment from case A against a non-party in case B. Now,
that wasn't my question.
If they have
yeah.
they may, I mean.
I got that, okay.
Okay. You know, whether they can do something different is another issue for another day.
Well, you're right, it is another reason for another day, but taking your theory further, that they can't do what they've tried to do, they've already brought their action, they've already sued their parties, they're probably res judicata as to any other action.
You know,
I don't know, you're right, it's another argument for another day.
Your Honor.
Right. But I'm trying to understand the remedy you want. The remedy you want is a reversal and a vacation of the judgment. Whatever happens next is their problem.
Reversal of the judgment here and entry of judgment for the estate, because the estate did move for a summary judgment on the ground. The notes aren't here. You can't sue us. That motion is at page 405 of the record, and it was denied at 550. So we are entitled to a judgment in our favor. The intervener on behalf of the estate entitled to judgment in our favor.
What do you make of the language in, I guess just for convenience, it's at head note 11, that paragraph, it says, even though such endorser was not made a party to the foreclosure and no notice thereof was given him, under our decisions, he is subject to such suit at law, and the entry of a deficiency decree against one of the makers of the note and mortgage for such balance found to be due does not change the rule. And they allow them to sue the endorser in a separate action for the deficiency that was adjudicated in the earlier action.
Okay. Your Honor, you've gotten me to my second reason why Young's husband doesn't apply, and that language doesn't apply anymore. And the Supreme Court has recognized that. So the first thing is you have to sue on the note. Okay, and what you just read there, they say you can go have a separate suit on the note. Okay, the notes don't exist anymore because under our modern practice, the notes are merged in the foreclosure action. So the way the law was in 1930 doesn't work anymore. You can't sue on the notes aren't there. So that paragraph 11 and 12, or head notes 11 and 12, whatever, about, oh, you can use it and consider it. Well, you can't, if you had a suit on the note you could bring, yes. There's no longer a suit on the note. That was the first point. Second point is the underlying rationale for what Young husband's trying to deal with has been taken care of. In 1941, the Supreme Court decided the Degay case. The Degay case, they overruled these. They cite to Privat, which had relied on Young husband, this one. They cite to a second Young husband case, and they go on to say, Degay says, it borders on the ridiculous to assert a court of equity could not enter a deficiency decree against an endorser. Borders on the ridiculous. So they changed the law. 1941, this 1930 law is gone. Doesn't work anymore. They decide that's not manageable. Why go have a second suit against a note more? I mean, I'm not sure why they did it, but clearly after 1941 with Degay, and you look at the cases that come after that, we cited one from the 60s and so forth, they can bring the maker, the endorser, they can bring whoever they want to into the original suit.
So I guess what your argument has to be then is if you have the maker of the note or the endorser that are not necessary parties to the foreclosure suit and you don't join them anyway, then you're just out of luck as far as collecting a deficiency against them later. Is that what you're saying?
No. I think in this case that is what's happened because of the way it's evolved. Whether there's some other way they could do it, I mean, they could perhaps proceed on it, but they can't do what they did here. Perhaps they could prove up in a fresh suit. They could prove up a deficiency, not based on the deficiency judgment, because that's not there. They can't use the judgment from case one that we weren't in, that the estate wasn't in case two. But are there some ways to do it? Yeah, I could think of ways to do it, and this isn't my practice area. But like I say, I'm not really here to educate them. You know, they didn't do it right here. They could have, as your question suggests, they could have brought the estate in. They say that. They even acknowledge that. The estate was a proper party. Was it a necessary party to a foreclosure? No, not necessary, but proper. And before 1941, not a proper party. That's why we have Young husband and the odd, taking offs from there. But that's no longer the law after 1941. That kind of gets to the third point of Young husband. The third independent reason why we can't take that and apply it to here. They want to say, well, we're just using it as evidence. We're not buying, we're just using it as evidence. And Young husband says you can use it as evidence. Well, Young husband says that the finding of deficiency, getting back to your footnote or your head note, may be admissible in evidence. May. not must, may be admissible as evidence for the balance due on the note in the second suit. Okay, balance due on the note. Well, they can't sue on the note. So that evidence, being able to use the evidence, they're gone on that. They can't do that. But let's think about this in 2015. That's a statement in 1930. Anything may be admissible as evidence if nobody objects to it. But if a party objects and says, I wasn't in that case, you can't use as evidence against me in today, and after the cases we see from this court from the 1980s and 2006, they can't do that. Consider a simple example. I think we had this in our reply brief, or a variation of it. Let's say you've got a plaintiff that's in a car crash with two other cars, and the plaintiff sues the first defendant and gets a judgment for $5 million. But the jury decides really the second defendant was primarily liable, that's 90% on them for the Fabre defendant. Okay. Plaintiff is undeterred. Plaintiff sues the second driver. And the plaintiff comes in and says, you know, I've already got a judgment for the damages. I don't have to prove up any damages. I'm just going to use my $5 million judgment against you, defendant 2, in this case. Nobody would stand for that today. That is not the law. Okay? And the problem is they weren't a party. As the Hutchison case and the other cases say, you can't use a judgment against the non-party. So, and if the plaintiff in the second case, if the only thing they put into evidence was their $5 million judgment from the first case, the defendant will be entitled to a directed verdict. And that's what we have here. The only thing they put in was this deficiency judgment. They said they didn't put the notes in, they didn't show any liability, they put in a judgment that she wasn't a party to. So that's what we have here. They have no proof that survives our motion saying give us a judgment. And again, as I say, they didn't even argue young husband. This is a new creation. It wasn't even in their summary judgment motion. So at a minimum, it had to be reversed for that. But there's nothing left to do here. This is a narrow situation we have. Because as your questions already note, most of the time, the bank is going to be astute enough to sue everybody. They're going to sue the maker. They're going to sue the party on the mortgagor. They're going to sue the endorser if there's still such a thing around. They're going to bring all those parties in. And that's what they should have done here. They didn't. I don't know why they didn't, but they didn't. And having not done that, they're not in a position to use the judgment from the first suit against them in the second suit. Briefly on the fees, of course, if we prevail, they get no fees for the appeal. But they've argued they still get fees based on the note. The notes are gone. They can't get fees based on the notes. Same problem. They want to pretend like the notes still exist. The notes merged in. They're gone. So, I'd ask that you reverse, enter judgment for the estate. As I say, it's going to be a very narrow situation where this happens. Not going to happen very often, because most banks are going to sue everybody, and after they see your opinion in this case, they'll certainly do it that way. Unless there are any questions, we'd ask you to reverse. Thank you.
Good morning, Your Honors. Patrick Ayers on behalf of Appellee Cadence Bank. The appellant is asking this court to reverse a final judgment that was entered against a party that was named and served in the action after it was confronted with substantial competent evidence of the party's liability and the amount of the damages for which it was liable by a court that had personal jurisdiction over that party and subject matter jurisdiction over the action. There is no error, fundamental or otherwise, with respect to such judgment. Appellant has completely ignored the uncontroverted evidence that was submitted in that action that supports the trial court's judgment for deficiency. The evidence was not the foreclosure judgment alone. The evidence was the affidavits of the bank, Michael Moore's, who specifically in his affidavit, which can be found at the record at the motion for summary judgments at 1331.
But the problem is, and I don't mean to interrupt you, but just, the problem is the whole notion of the deficiency is based on a judgment rendered in a court which neither the estate nor the decedent was a party. And that's obviously the trouble and the problem that everybody has when they look at this case. The whole essence of the cause of action for a deficiency is predicated on a judgment rendered by a court which the party against whom the deficiency is being sought were not brought in, and they could have been brought in.
Well, let me address that. They were not a party, and they did not need to be a party. We acknowledge they were a proper party.
They weren't a party, they didn't need to be a party, but they could have been a party.
Well-
And if somebody was thinking down the road about a deficiency, they probably would have been a party.
Let's keep this in mind. The estate, the decedent, who was the borrower, was not the owner of the property. They were not the mortgagor. The complaint that was filed was a 2-count complaint for foreclosure only. Only in rem relief was sought in the case. The borrower, decedent in this case, had no interest in the land. She wasn't the owner. So while she was a proper party, she really wasn't necessary to the relief sought, foreclosure. In reality, no deficiency could have been sought in the foreclosure because she wasn't made a party. Longstanding Florida law has always acknowledged that a mortgagee or lender has alternative remedies. They're independent and exclusive. They don't have to be pursued altogether. You can file simply a foreclosure count.
Well, the problem, what it appears, and again, I'm just surmising here. It appears that the foreclosure was brought during the foreclosure crisis when all lenders want is give me the property back. They weren't seeking deficiencies. Well, that's kind of passed a little bit. And now some of these lenders have gotten back properties that were way undervalued from what they had. They have taken a big loss. Now all of a sudden deficiencies are reawakening again. And the trouble is the expediency of bringing a foreclosure just to get the property back usually is not going to be people aren't going to defend it, generally speaking. Not going to be much of a defense mounted. If there's a thought that there's going to be a deficiency out there, there's going to be a little more of a defense. It was a strategic move on the bank's part, is what it appears to me. A strategic move on the bank's part, and I just, quite frankly, don't think they were thinking all the way down the road.
Well, the reality, Your Honor, is that we had no claim at that time. The only claim we were going to have against the estate was for a deficiency if one existed. For us to have stopped the foreclosure, we would have had to create an estate. It wasn't our burden to do that. It was really the beneficiaries or the heirs to do that. We didn't have to do it. We had the right to simply foreclose our mortgage. We were minimizing and mitigating our potential claim against the estate. The deficiency was always going to be a claim in the probate estate. So by foreclosing, if we waited, waste could have occurred more, the value could have dropped even more, the deficiency claim against this probate estate might have been much more significant than it already was.
Deficiency is probably less now.
Well, whatever, but we did not have we might not have had a claim, or maybe the deficiency at the time would have been nominal enough that it wasn't worth pursuing. So there was no reason to stop the foreclosure. And Florida law is clear. You don't have to name the party who is liable for the deficiency in that action, and that doesn't preclude the party, or the lender in this case, from then using the foreclosure judgment later on in the action. It's not uncommon where guarantors aren't named in the foreclosure, and then once the foreclosure is complete, if there's a deficiency, then a separate action is brought against the guarantor.
But that's a separate action on the contract of guarantee, on the guarantee itself. You don't have that here.
That's true.
You're suing strictly, you're not suing on a note, you're not suing on a mortgage, you're taking a judgment on a foreclosure and bringing a deficiency action against a party that was not a party in the foreclosure.
Well, if we look at actually what happened here, is because there was no estate, in order for us to pursue our claim for a deficiency, I think we all agree that what we had following the foreclosure was a deficiency. And what is a deficiency? It's the balance due after foreclosure, after applying or offsetting the greater of the sale proceeds or the value of the property. That's what a deficiency is. We had to file the probate, an involuntary probate, to assert that claim. I mean, we never would have gotten as far as we were if there wasn't a deficiency, but there was, so we had to institute a probate proceeding, and under the probate code, we have to file a claim, which we timely did. The beneficiary, in the case, the appellant here, filed an objection to that claim. If they never filed an objection, that claim would have been allowed and stood as is. Because they filed an objection, the probate code required that we filed a separate, independent action.
I understand what you did. You basically did everything right, except for not bring her in the main action on foreclosure.
But we didn't have to put her into the...
You didn't have to, but if you were looking for a deficiency, you had to.
I don't think so. I don't think there's any case that holds that the only way you can use the foreclosure judgment against a non-party is if that party was in the foreclosure. That's not what the case law suggests.
Well, point me to that case.
Well, I mean, the young husband case, if we look at that, granted, under the law in that time, you couldn't name the endorser. So we didn't have the merger of equity and law courts. The note didn't merge on the chancery side. You could bring your separate action on the note. Well, now we've done away with that. The note does merge. That's why young husband doesn't address merger at all. None of the Supreme Court cases back then, because you had a distinction between equity courts and law courts. The note still existed. You could, as the young husband, as counsel indicated, the young husband makes reference to the deficiency rule as an action on the note, on the original obligation. Today, we don't have that original obligation. The judgment is the note. It is the evidence of the debt. That's why the cases which say what a deficiency is, it's the balance due after foreclosure. Well, the balance, the amount, is in that judgment. It's different from his argument regarding using a judgment entered against tortfeasor A and a separate action against tortfeasor B. You don't have merger there. Here we do. We don't have a note. The note is in the judgment. That is the evidence of the debt. So there's really nothing different.
Well, let's take that. If the judgment instead of the note now is the evidence of the debt, did the estate have the right to challenge or dispute the amount of the judgment in the second action, or is that somehow just become a given?
No, absolutely. They were not a party. They're not bound by the rulings. They could have presented whatever evidence they felt was necessary to test either the amount as well as the value that therefore would have changed perhaps what the deficiency was. They never did that. All they've ever tried to do in this case is to shut the courthouse door and prevent us from getting a remedy. We didn't do anything wrong. We followed the proper procedure. And I would submit that there is no error, but if this court were to find, it wouldn't entitle the appellant to a judgment. We properly filed our claim, an independent action. If you find error because it was based solely upon the foreclosure judgment, well, it was entered as a summary judgment based on that, then it goes back to the trial court to put us to our proof, whatever that may be, whether it's at trial or under another motion for summary judgment if there's other evidence that we can put forth. But there's no basis for a judgment to be entered in favor of the appellant here if there is a reversal. But again, it's critical to understand the foreclosure judgment is the debt. There's no note, there's nothing else. So the only thing we can rely on in the cases, and the second district has, in the Empire Developers Group case, which was cited in our brief, adopted the Morgan case out of the third district, which sets forth what the formula is for a deficiency. The starting point is the foreclosure judgment. That is the amount that was found due. That's all a foreclosure judgment does. Determines the amount due. It doesn't impose liability on anyone, and it sets the sale. So the starting point is that foreclosure judgment. It's whatever that amount is, less the greater of the sale proceeds from the foreclosure sale or the value of the property. That's the resulting balance. That's what the deficiency is. So it's not necessary to bring the estate into this foreclosure case in order to use it against it. It can be used, that judgment is the amount of the debt, it is the evidence, it is the starting point, and the cases that we've cited in our brief clearly support that. So there's nothing that's been done to deny any due process here to the estate. The estate was named in this independent action, got served, had an opportunity, and was confronted with evidence. The affidavit clearly stated that the decedent executed and delivered the promissory notes. Then goes on to provide that the amount that's due now as a deficiency is the amount as stated in the foreclosure judgment, less the value of the fair market value of the properties as determined by the affidavits of the appraisers that were filed with the motion for summary.
Did the estate offer any money contesting the amount of the debt or the valuation placed on the property?
No, no evidence was presented by the estate or the intervener at any point below. And let me add to that. As I indicated, the foreclosure action that we brought was just for foreclosure, just in rem relief. And we obviously had to name the mortgagor owners. Well, the owner of the two units was a trust. And we named the trustees, both in their capacity as trustees and in the case of Mr. Atzenhoefer, who is the appellant and intervener in this matter, in his individual capacity because he signed the mortgage individually as the beneficiary of the owner trust entity. In that foreclosure case, as a party, he had the right and opportunity to contest the amount and raise whatever defenses. He did file an answer. The trial court found the defenses insufficient and entered the final judgment of foreclosure determining the amount due. So they've had two opportunities, both in the foreclosure and in the independent action in which to present evidence or contest the amounts due, and they didn't do it in either case. There's no error. They have not been denied their due process. There's no harm or no prejudice to them because they've been given fair opportunity to present evidence and did not. With respect to, one final point with respect to the attorney's fees that we saw, because we have not had a chance to address that in any formal response. The case that's been cited in appellant's response to our motion for fees, the Nabavi case, which is a bankruptcy court decision, Middle District of Florida, is actually very supportive of our position for fees. Their argument as to why we're not entitled to fees is, well, there's no note. It's merged into the judgment, which we agree. It has merged. But that doesn't terminate the identity of the provisions of the note. The merger doctrine is a very narrow doctrine. It simply means that the cause of action on which the judgment has been entered has been extinguished, the debt. In this instance, we could no longer sue for the face amount of the notes. We foreclosed on it. We realized collateral. We could only go after the balance that was due. That's the deficiency. That's not the same cause of action as a foreclosure. No action was extinguished there. No case holds that the merger doctrine extinguishes the attorney's fee provision in the note. In fact, the Nabavi case clearly rejected that argument, both at the bankruptcy court trial level and at the district court appellate level. They rejected that very argument, that the merger doctrine terminated the entitlement to attorney's fees. And if you look at it from a practical standpoint, you might be faced with a situation where a lender who only brings a foreclosure action doesn't name the borrower doesn't contest the foreclosure, note merges into the foreclosure, then you subsequently bring a deficiency action, and wham, borrower hits you with all those defenses and argues, well, you can't get attorney's fees now because the note's merged. The lender's going to be caught holding the bag there with substantial fees, probably having to defend the defenses to the deficiency action in that situation. But there is no case that holds that the merger doctrine terminates the entitlement to attorney's fees provision. In fact, the third district in the MSI case clearly holds on appeal that the lender was entitled to an attorney's fees under the note in a deficiency action, although it did not consider the merger doctrine and what effect it might have. So unless there are any further questions, we'll stand on the brief.
All right, thank you, sir. All right, Mr. Elliott, I'll give you 5 minutes for rebuttal.
Thank you, Your Honor.
You had time left?
Yes, thank you. Starting with the last point on the fees, the bankruptcy cases hold that the notes are merged into the foreclosure. The only reason the one case allowed fees was because the borrower had sought fees on the merged note that no longer existed. And they said, well, if you sought the fees, we're going to allow the fees to be awarded against you. That was the basis for the decision in the bankruptcy court allowing fees. When you take a look at Judge Honeywell's opinion and what she says, clearly they can't do what they're trying to do here. But they shouldn't get fees because for the reason that they should lose this case. And to briefly respond on the merits, 702.06, section 702.06 says you can bring a separate action or you can seek the deficiency in the action. But that statute never addresses trying to bring a deficiency action against somebody that you didn't sue in the first action and you want to use the judgment against the second action. It doesn't say that. It doesn't say you can say that. And I think you heard today they couldn't cite you a case that supports what they're doing, what they did here. Let me
ask you this question.
Yes.
Counsel said that if you guys had wanted to, you could have contested the amount of the debt and offered your evidence as to the value of the property and said you didn't do that. So do you agree? Could you have contested the amount of the debt in this second suit?
Your Honor, the way it came down was you've got them foreclosing. They get the properties themselves. Then they have them appraised and they put a value on the properties of what they say. They don't sell the property. There's nothing that says we sold these at arm's length. Yeah, are there things we could have done in the second? I think there's some things that were foreclosed because we weren't in the first suit. Are there things that could have been done in the second suit? Perhaps. But the point is there's no obligation on the defendant to set a floor. If their proof is insufficient.
Well, wait a minute. My question was, in the second suit, are you bound by the amount of the judgment?
I don't know how you go.
Or can you contest the
I don't know how
amount
you
of
go
the
back and
judgment?
challenge the reasonableness of the sale. It's all happened. It's long ago.
Well, please, just answer my question. Could you have challenged the amount of the judgment debt? Yes or no?
I guess you could have said we challenge it. I don't know how you could have effectively done that. Legally, could you have done that? I don't know, perhaps. But I don't think it makes any difference here because it was not incumbent on the defendant to come in and say, yeah, it's not really worth 612, which they're seeking. We think we can whittle it down to 300 because they had failed in their proof on the case. We don't have to set a floor for them. They cannot cure. They're saying, oh well, we didn't sue her because we had to open an estate in the first case. They opened an estate for the second case. That's where they opened the estate, so they could pursue the deficiency. They could have done that for the first case. They didn't. Whether it was for the reasons Judge Moore suggests or some other reasons, it doesn't really matter. They didn't do what they should have done to perfect this claim. They cannot cure it now because the foreclosure judgment is done. The estate wasn't a party to it. It's gone. I mean, it can't be used in the second case. The notes are gone. They are not suing on the notes in the second case. They are suing on the foreclosure judgment for which we were not a party. The suggestion that, oh well, he was in the first case because he was in the first case as a trustee, a pro se trustee, Mr. Atzenhoefer was. In the second case, he intervened on behalf of the estate. The estate is a separate party from the trust. Everybody agrees to that. They admit that in their answer brief. So the fact that he was in the case as a trustee in the first case does not have anything to do with his intervention as the estate in the second case. So you can't take the one and bootstrap it. They clearly didn't do what they needed to here. Again, we're asking for a narrow ruling. I don't think this will happen again once you write on this and the banks get clear on what they're supposed to do. I don't know that it's happened again since then. Thank you.
All right, thank you both. Very interesting. At this point, we're going to take a 15-minute recess, and we'll come back and do the last case.